Hello everybody and welcome to the last Mayor Brown webinar of 2022. My name is Andrew Block, I'm a partner in the pensions team and I'm joined by Alex Knowles-Smith, who is an associate in the pensions team, and for the next hour, well 40 minutes or so, we're going to be talking about corporate refinancings and the Pension Schemes Act 2021. This session is being recorded and we will be circulating the slides and the speaker notes afterwards. If you've got any questions, please do put them in the chat and we will either deal with them as we go along or at the end. So without further ado, I will pass on to Alex and ask him to kick off.
Thanks, Andrew. So starting off, I'll flesh out some of the historic background to the new regime. Next slide, please, Andrew. So this is Dominic Chappell, who owned 90% of Retail Acquisitions. In 2015, the company bought BHS from Sir Philip Green for £1 and extracted just over £2.6 million from BHS before it collapsed in 2016. At that time, the BHS pension schemes had a £571 million deficit. You may remember that the PPF and the regulator threatened action against Sir Philip Green, who in 2017 agreed to pay £363 million towards this deficit to avoid the BHS schemes having to enter the PPF. As for Chappell, he was pursued on various criminal charges, which culminated with him being found guilty of tax evasion to the tune of £580,000 in November 2020. He was sentenced to 6 years in prison. The BHS fiasco pushed corporate insolvencies and pension schemes right into the centre of a political storm. Next slide, please, Andrew. This is Frank Field, or to use his full title, the Right Honourable the Lord Field of Birkenhead. Frank Field chaired the Work and Pension Select Committee, which investigated the collapse of BHS and published a scathing report in July 2016. Next slide, please, Andrew. To quote from the committee's own website, the report documents the systemic plunder of BHS at the cost of the 11,000 jobs and 20,000 people's pensions now at risk. Sir Philip Green, Dominic Chappell and their respective directors, advisors and hangers-on who all got rich or richer are all culpable, with the only losers the ordinary employees and pensioners. In December 2016, the committee published a report on DB pension schemes, which included recommendations about the powers of the regulator. The committee also looked at other high-profile corporate collapses where pension schemes were involved, including British Steel, Halcro and Bernard Matthews. The committee found that the regulator had a substantial suite of powers, but was reluctant to use some of them. The committee's recommendations included a requirement for obtaining mandatory clearance from the regulator for certain corporate transactions and power for the regulator to levy punitive fines, up to 3 times the amount of a contribution notice. These two are Damien Green and Richard Harrington, who were respectively the Secretary of State for Work and Pensions and the Pensions Minister in February 2017. At that time, they issued a green paper to take forward the committee's reports. This consultation document asked for views on the compulsory clearance of certain corporate activities, as well as the other proposals to beef up the regulator's powers. Many responses to this consultation cautioned against compulsory clearance, arguing that this would only stifle corporate activity. By the time of the 2017 Conservative Manifesto, the idea that something must be done had taken on a life all of its own, irrespective of what the regulator had said to the Select Committee. This led to a white paper in March 2019 under the new Work and Pensions Secretary, Esther McVeigh. The white paper proposed to give the regulator various powers to punish those who deliberately put their pension scheme at risk. This included punitive fines, new criminal offences, and information gathering powers for the regulator. And all of the above finally led to the Pension Schemes Act 2021, which mostly came into force in October 2021. Essentially, the regulator now has new powers that it didn't ask for and didn't particularly want, but now has to use. I'll hand back to Andrew now to talk through the criminal offences under the Act.
Thanks, Alex. So the last point Alex made, I think, is quite important. The powers that the regulator has under the Pension Schemes Act 2021 aren't as a result of the regulator thinking about what it would need to do in order to regulate corporate activity and stop another BHS from happening. It's the result of a fairly knee-jerk reaction from the Select Committee and from Parliament, which has given the regulator certain powers that Parliament now expects the regulator to use, and the regulator will be wary of another BHS happening when it hasn't stepped in using its new powers. But they haven't actually asked for these powers. They had to scramble around to work out how they were going to exercise those powers and in what circumstances they would exercise those powers. And of course, especially with the criminal offences, what they can't afford is for their first prosecution to be a complete fiasco in the way that we've had some fairly high profile failures of prosecution from the FCA. So they will be quite selective. They will be looking for cases where they can convince a jury that what has happened isn't honest people doing their best but falling the wrong side of the law. What has happened is an attempt at a Dominic Chappelle style extraction of money from a failing business, or an attempt to put corporate profits ahead of a pension scheme in a way that is way beyond what a normal business would do, asset stripping and the like. So let's have a look at the new criminal offences. And the first one is a criminal offence of avoidance of employer debt. So when in certain circumstances, a pension scheme will owe a debt to the employer under Section 75 of the Pensions Act, and that is usually triggered by the insolvency of the employer or the winding up of the scheme, or a company coming out of a pension scheme and other companies are still in it. So the new criminal offence, a person commits an offence if they engage in an act or a course of conduct which prevents the recovery of the whole or any part of a statutory debt, prevents such a debt from becoming due, compromises or settles it, reduces the amount of the debt which would otherwise have become due, and the person intended the act or course of conduct to have such an effect, and the person didn't have a reasonable excuse for doing it. And we'll come on to what reasonable excuse means in a minute. It only applies to defined benefit pension schemes, and the maximum penalty is an unlimited fine or 7 years imprisonment. Prosecutions need the consent of the Secretary of State or the Director of Public Prosecutions, and what that means is that trustees of a pension scheme can't bring a private prosecution. It has to be the regulator or the DPP. And it also doesn't cover anything done by an insolvency practitioner. Alongside this new criminal offence is a new power to issue a financial penalty covering the same set of circumstances. If someone was party to an act or deliberate failure to act, the main purpose of which, or one of the main purposes of which, was to prevent the recovery of a statutory debt, to prevent it becoming due, to compromise or settle it, or to reduce it, and it wasn't reasonable for the person to act or fail to act in the way that they did. And what this means is that, a bit like HMRC, the regulator is a discretionary prosecutor. If it sees a set of circumstances where it brings this section of the Act into play, it can either try to issue a contribution notice, or it can issue a financial penalty, or it can prosecute, or it can do all three, or it can do any combination. And it is likely to be using these powers and the threat of these powers to try and enforce what it would see as good behaviour, and make sure that it never actually has to issue penalties or prosecute. It would much rather companies voluntarily, as it would see it, did the right thing and supported their pension schemes, and it will be using the tools it's got to try and encourage behaviour. We've similarly got another new criminal offence, conduct risking accrued scheme benefits. This is a bit wider. A person commits this offence if they do an act or engage in a course of conduct that detrimentally affects in a material way the likelihood of accrued scheme benefits being received. They knew or ought to have known that the act or course of conduct would have that effect, and they didn't have reasonable excuse. And again, we'll come on to what reasonable excuse is in a minute, because that's quite important. And a reference to an act or a course of conduct includes a failure to act. It includes turning a Nelsonian blind eye, not asking the obvious question, that sort of behaviour. Again, it excludes reduction of benefits on entry to the PPF, excludes anything which an insolvency practitioner does, only applies to defined benefit schemes. Again, the maximum penalty is an unlimited fine or 7 years imprisonment. And again, prosecutions need the consent of the Secretary of State or the Director of Public Prosecutions. So the trustees can't initiate private prosecutions. And as with the previous criminal offence, there is a power of the regulator to issue a financial penalty of up to £1 million in the same set of circumstances. So again, the regulator is a selective prosecutor. And just a quick word on who is a person. The regulator can exercise these new powers against any person, that's any company or any individual, in theory, anywhere in the world. This contrasts with contribution notices, which can only be issued against individuals or companies that are connected or associated with an employer in an occupational pension scheme or are themselves employers in occupational pension schemes. What the regulator has said is that it is unlikely to exercise its new powers against somebody who is not associated or connected with an employer in an occupational pension scheme, unless circumstances exist which would allow them to issue a contribution notice if they were so connected or associated. So it's trying to tie in the circumstances in which it would exercise these powers into circumstances where it would issue contribution notices.
So I'll give some of our thoughts now on the regulator's new powers. So just to first explain this slide, this is actually a real witness statement, somewhat tangential, but the Crown Prosecution Service kept asking for a witness statement from a certain PC Peach, not realizing that Peach was actually a police dog. Eventually, Peach's handler sent them this, and needless to say, the CPS was not amused. Some highlights of the regulator's policy include not prosecuting behavior that it considers to be ordinary commercial activity, only investigating and prosecuting the most serious, intentional or reckless conduct, and in general taking a risk-based and proportionate approach to using its powers. Essentially, the regulator will consider prosecuting only in circumstances where it might otherwise consider a contribution notice, that is for egregious, blameworthy behavior. Next slide, please, Andrew. So some more thoughts on this. First, under the twin track approach, the regulator will have the choice of pursuing a criminal prosecution, a civil penalty, or both. Presumably, the regulator will use the threat of criminal prosecution to secure better outcomes for the scheme, as Andrew mentioned. We're going to cover the reasonable excuse concept in a bit more detail later, but I'll say here that the regulator's criminal offences policy makes clear that the reasonable excuse concept will probably be imported from the existing contribution notices regime. One key difference is that due to the criminal offence context, it will be for the prosecution to prove beyond a reasonable doubt that the defendant did not have a reasonable excuse. Sorry, back one slide, Andrew. Moving to the next point, the regulator's powers are wider than for contribution notices because the regulator won't have to show association or connection. And finally, the criminal offences require knowledge. Prosecution will have to show beyond a reasonable doubt that the defendant knew or ought to have known that the course of conduct would have its effect. In particular, the meaning and practice of ought to have known is currently unclear. First, so some more thoughts here on this slide. First, prosecutions will be before a jury in a Crown Court. In our view, jurors are likely to struggle to understand these legal concepts. This is relevant because the regulator is likely to prosecute only where it thinks a jury would actually find that the conduct passed the threshold for a criminal offence. Secondly, the timescale for prosecution could take years. This is a problem for advisors faced with a threat from the regulator to prosecute, because it's not much comfort to a client to tell them not to worry on the basis that in 2 years' time, when the case finally gets in front of a jury, the jury is only likely to clear them. Next, regarding the test for prosecution, the regulator has said it will apply the two-stage test for Crown prosecutors. This entails the evidential test, that is, on the evidence before the jury, is there a realistic prospect that the jury would convict, and the public interest test, that is it in the public interest to prosecute? Next point, the regulator is likely to approach prosecution in a similar way to the FCA. In fact, the regulator's head of enforcement is himself ex-FCA. And finally, it will be more important than ever to document decision-making to show the reasonable excuse defence, which Andrew will explain now.
Thanks, Alex. So just to pick up on Alex's point about the importance of documenting decision-making, because the criminal offences and the power for the regulator to issue £1 million penalties revolves around both an act and also an intention. If you document the fact that you are engaging in proper, genuine commercial activity for a corporate reason, and also that you have considered the impact on the pension scheme, and you have decided either you're going to offer mitigation or you don't think there is a detriment, and so you don't need to offer mitigation. If that's all documented, it makes it much easier for you to show that you are not falling the wrong side of the line. And in particular, when the regulator comes to look at reasonable excuse, you've got something to show the regulator, to show that you weren't intending to undermine the pension scheme, and that you should fall the right side of the line. So when looking at reasonable excuse, the regulator will consider each person's reason for acting as they did in isolation, unless parties acted together. And the example the regulator gives here is of a lender. It says, for example, where a sponsoring employer is extending its borrowing, whether a lender has got a reasonable excuse is not affected by the reasonableness of the actions of the employer or its directors. They're looked at separately. The regulator will look at the circumstances in which the act took place, and will take account of the person's own circumstances, including their duties, skills and experience. And the regulator's guidance explains that circumstances expressly includes time constraints. Especially in corporate rescues, time is a huge factor, and the fact that the regulator is taking into account time constraints is, I think, quite helpful when it comes to looking at behaviours in corporate rescue situations, in corporate distress situations, where time is critical. When the regulator says it will take account of a person's own circumstances, including their duties, skills and experience, that includes any professional duties that a professional advisor, such as a lawyer or actuary, are under. The regulator will look at whether they have breached the guidance or the rules of which they're under issued by their professional bodies. The regulator has also said that 3 factors will be significant in its assessment: the extent to which any detriment to the scheme was an incidental consequence of what happened, or whether it was central; whether any mitigation was offered to offset the detrimental impact, and if so, how adequate it was; and where no or inadequate mitigation was provided, whether there was a viable alternative which would have avoided or reduced the detrimental impact. I think the regulator is recognising here that sometimes, with the best will in the world, things go wrong, especially in corporate rescue scenarios, and sometimes detriment to the scheme is simply unavoidable. Other relevant factors: the extent of communication and consultation with trustees before the act took place. One of the differences that this legislation will make in corporate transactions is it's important to think at a very early stage: is there likely to be detriment to a pension scheme? Do we involve the trustees? If there is, what do we say to them? What sort of a package do we put to them? The regulator will take that into account. In the case of a person who owes fiduciary duties to the scheme, which is the trustees, not the employer, there's case law to the effect that employers don't owe fiduciary duties to their pension schemes, whether the trustees or others with fiduciary duties complied with those duties. And I've said where somebody is acting in a professional capacity, whether they acted in accordance with the applicable professional duties they're under. And the regulator's given some fairly helpful examples of where it thinks there would be a reasonable excuse. As a side effect of ordinary business activity, for example, a customer terminating a contract, a bank calling in a term loan at the end of the term, that sort of thing. Industrial action, so the regulator won't be prosecuting unions. Banks deciding not to lend because a borrower has a defined benefit scheme. And this one is potentially quite useful. The example given is where a parent has got 2 subsidiaries, one with a defined benefit scheme and one without, and the parent decides to invest in the one without. There is a fine line between that and a parent deciding deliberately to starve a subsidiary which does operate a DB scheme of cash, knowing that that is likely to cause the subsidiary to fall over and the scheme to fall over. But it is helpful that the regulator appreciates that the fact that a company may be operating a defined benefit scheme is a factor that is taken into account when making investment decisions. And just quickly and for completeness, we'll just run through some of the regulator's other new powers. It's got a new power to issue a contribution notice under what it calls the employer insolvency test. This is where a scheme is in deficit on a buyout basis, and there has been an act of failure which would have materially reduced a statutory debt had one been triggered. A couple of statutory defences. The person gave due consideration to the fact that the act or failure to act might materially reduce the statutory debt, and having regard to all the circumstances, it was reasonable for them to conclude that the act or failure wouldn't have the effect, or the person considered that the act or failure might have that effect, but took all reasonable steps to eliminate or minimise it. And again, this shows the importance of documenting your decision making so that you can show that you do have a reasonable excuse, you did consider it. The other one is an employer resources test. This is where an act or failure to act reduced the value of an employer's resources, and the reduction was material relative to the scheme's estimated statutory debt. And again, a couple of statutory defences. You gave due consideration to the extent to which the act or failure might reduce the value of the employer's resources. Having regard to all relevant circumstances, it wasn't reasonable to conclude that the act or failure would not bring about a material reduction, or you considered that the act or failure to act might have that effect, but took all reasonable steps to minimise or eliminate it. And again, it shows the importance of considering and documenting what you're doing so that you've got some evidence that you're within the statutory defence. There's also a new criminal offence of failing to comply with a contribution notice, which is a requirement and order by the regulator that the recipient pays money to the pension scheme. As well as having to pay the money on the contribution notice, the regulator can impose a fine effectively of up to £1 million and can prosecute. And although the prosecution for failing to comply with a contribution notice, it's only a summary offence, it would only be prosecuted in a magistrate's court, the maximum penalty is only £5,000, it would result in the recipient receiving a criminal record. And there is a new power for the regulator to issue a civil penalty of up to £1 million for knowingly or recklessly providing the regulator with information which is false or misleading in a material particular. This is important given the new requirement to involve pension scheme trustees at an early stage in transactions, or at least to consider whether to involve them. If you are going to give information to your pension scheme trustees, make sure that it gives them a complete picture. Don't give them half-truths or a partial picture. It is possible to ask pension scheme trustees to enter into confidentiality agreements to receive that information, and in certain circumstances you also need to consider whether you are bringing them inside in relation to any insider rules. And finally in this section, some new notifiable events. Alex mentioned at the beginning that one of the recommendations coming out of the report of the Select Committee was that certain transactions need to be cleared by the pensions regulator, i.e. you have to go to the regulator in advance and get the regulator's permission to complete the transaction. That's been watered down fairly significantly. It's now not a requirement to clear transactions through the regulator, but you will still have to tell the regulator of certain transactions. We don't quite yet know which ones. The requirements aren't yet finalised. We're still awaiting a government consultation response. Obviously, if you have to tell the regulator, the first question the regulator is going to ask is, have you told the trustees? What do the trustees think? So before you tell the regulator, you would need to talk to the trustees. If there's going to be any detriment to the trustees as a result of the transaction, address that with the trustees. So when you go to the regulator, you're telling the regulator, this is what we're doing, and we've told the trustees, and the trustees are happy, and here's a letter from the trustees confirming that they're happy. And then that way the regulator closes its file, and you don't end up with the regulator trying to get involved in the transaction. So over to Alex for some thoughts.
Thanks, Andrew. So I'll just reiterate some of the practical steps that you can take depending on your role in respect of a pension scheme. So first, what should you do if you're a lender? The headline points are that you won't be in scope for a contribution notice or financial support direction, and you shouldn't be in scope for criminal prosecution unless you know something wrong is happening and turn a blind eye. In this context, sensible steps essentially involve careful planning and due diligence, keeping a written record of decisions, and taking advice where necessary. How about if you're a corporate buyer, seller, or reorganizer? Well, there's a greater danger of being in scope of the regulator's powers, but sensible action can mitigate this. Sensible steps here involve notifying the scheme trustees and perhaps the regulator, careful planning and due diligence in dialogue with the trustees and again, perhaps the regulator. And as for lenders, keeping written records and taking advice where necessary. If you're a trustee, the steps to take mirror those for the company side. Essentially, they involve implementing mechanisms to establish and improve that dialogue and flow of information from scheme sponsors. When notified of a refinancing, steps may involve speaking with the lender and the regulator. And as before, trustees should keep written records and take advice where necessary. Finally, for distressed debt scenarios, the law is the same, but there will be additional time pressures, which will influence what the regulator considers to be reasonable. As mentioned at the start and throughout, normal commercial activity is unlikely to be caught, but the regulator will be alert for pre-pack administrations with a strong overlap between the administrators and the investors, and asset stripping acquisitions, even where the alternative to a sale would have been liquidation. And back to you now, Andrew.
Thanks, Alex. And the point on pre-packs is quite important. There have been a couple of cases where the managers and investors of the business that is pre-packed and the business that the company that rescues or buys from administration the assets of the business that's been pre-packed are very similar, and those do trigger warning bells at the regulator, even where there is a good commercial rationale. It's a bit of a red rag to a bull. So if you are going to do something like that, you do need to think very carefully and make sure you obtain advice in relation to protecting the pension scheme and documenting that you've properly protected the pension scheme to the extent that you can. So we're going to look at the last sort of 10-15 minutes of this session at a case study, and this is a case study that the regulator gives in its policy on prosecutions to try and explain when it might prosecute and when it might not. It's looking at a company, parent company P has got shareholders, parent company has an operating company underneath it, employer E. The operating company's got a pension scheme. It's also got a customer C, and in terms of capital for the operating company, it's got a term loan from an overdraft facility from a bank B, and it also has working capital from its parent company by way of intercompany loans that, as with most intercompany loans, are repayable on demand. And the scenario the regulator posits is that we're in a declining industry where if customer C terminates its contract for services, it's going to be very difficult to get a replacement, and the termination of that contract is likely to result in the insolvency of the employer. The scenario the regulator gives is that the parent company hasn't paid a dividend for 3 years and the shareholders want it to pay a dividend. It's a declining industry, and the shareholders are primarily concerned that if the customers walk by the time the employer has paid off the bank and paid off the pension scheme, there isn't going to be anything left for them. So what the shareholders do is they say to the parent company, well, pull back your loans, demand repayment of those loans, and use the money to pay a dividend. So the parent company does just that. It demands repayment of the loans from the employer. But the employer doesn't have the cash. So what it needs to do is find some finance in order to be able to pay back the loans. The scenario the regulator gives is that the bank won't provide the additional headroom. So the employer goes to a new lender and tells the new lender that it wants to extend its headroom. Doesn't tell the new lender that if customer C walks, the whole thing will come crashing down, doesn't tell the new lender that it's going to use the additional headroom to repay the working capital so that the parent company can pay dividends. The scenario also posits that at this stage the employer realizes that the customer C is likely to walk. So what happens is the new lender comes in, lends at a higher rate, greater amount of money, as with most lenders, takes fixed and floating charge over all of employer E's assets. So the employer pays back the bank, pays back the working capital, and the parent company pays a dividend. And then lo and behold, the customer walks, and that causes the whole thing to come crashing down. So what happens is the employer goes into administration. The new lender, because it has got security, fixed and floating charges over the employer, is able to recover the money that it's lent. But the pension scheme and the other unsecured creditors are left with pennies in the pound, because a statutory debt owed by an employer to a pension scheme ranks as an unsecured debt. So what the shareholders have effectively done is prioritised the payment of a dividend to them over the repayment of debts owed by the employer. And so in that set of circumstances, the regulator has set out its thinking as to what it would do. And this is aside from the fact that various other bodies will be interested in the decisions of the directors of employer E in these circumstances, in prioritising a dividend payment in circumstances where they knew or reasonably suspected that their customer was about to walk. This is just focusing on the regulator and the pension scheme. So what could the pensions regulator do in terms of prosecution? Well, the first thing it would consider is the offence in Section 58 of the Pension Schemes Act. Has there been a course of conduct which detrimentally affects in a material way the likelihood of accrued scheme benefits being received? And did the person know or ought to have known that the act would have a material detrimental effect? And did they have a reasonable excuse? A further test, which isn't in the legislation, but one which the regulator would apply, is it in the public interest to prosecute, and is it more likely than not that a jury would convict, bearing in mind that the criminal test are beyond reasonable doubt? That is probably more important than the regulator gives priority to it in its published guidance, because the regulator would not want its first prosecution to be a complete fiasco. So who could the regulator prosecute? Well, the example given are of potential targets: the employer, the parent, the bank, the lender, the customer. Sorry, the difference between the new lender and the bank are two different people. The customer, it doesn't give the shareholders as potential targets for prosecution. Even though I guess if you're talking about one shareholder rather than a bunch of shareholders, and it was easy to identify an individual that was putting pressure on parent company, they might be in the frame as well. So let's look at employer. So has the employer carried out a course of conduct which detrimentally affects in a material way the likelihood of accrued scheme benefits being received? Well, yes, it has. It has taken out a new loan at a higher rate of interest so that it can pay back working capital to the parent company. It has granted fixed and floating security to the new lender over its assets. Is the mental element of the test met? Did the person know or ought to have known that the act would have a materially detrimental effect? Well, that sort of depends on whether or not the employer knew or reasonably suspected that the customer was about to walk, and the sort of degree of knowledge. If the employer definitely knew that the customer was going at the time that it took out the new loan, then yes, it's met. If the employer didn't know, probably not met. There's a grey area in the middle there. The scenario that the regulator posits is that the employer knew. Was there any mitigation for the pension scheme? No. Was there an alternative course of action? Yes, it could not have taken out the additional borrowing. Well, if the parent had called in the working capital, that would have led to the probably led to the collapse of the employer, but the pension scheme would have been better off because there would have been some headroom there to pay it, and the new lender wouldn't have had the fixed and floating security. Other factors: was it open with the trustees? No, didn't tell them anything. Is the prosecution in the public interest? Yes. Decision: prosecute the employer and its directors. What about the parent? Well, it's the same thought process. The act is met. The parent called in the working capital loan. The mental element is met. It knew the employer didn't have funds to pay the dividend. It also, in the regulator scenario, knew that the customer was likely to terminate its contract, and that would likely lead to the employer's insolvency. Again, if it didn't know that, query whether the mental element would be met. Was the detrimental impact on the pension scheme incidental or central to what the employer did, to what the parent did? Well, it was central. It wanted a dividend before the employer became insolvent and knew that it was unlikely to receive one once insolvency had happened, because the pension scheme and the bank and lender would rank ahead of it. Was there mitigation for the scheme? No. Was there an alternative course of action? Yes, it could not have demanded the dividend or recalled its loan. Other factors: it clearly pressurised the board of the employer. Is the prosecution in the public interest? Yes. Regulator's decision: prosecute the parent company and its directors. And then the regulator looks at who else it might be able to prosecute. So first of all, looks at the bank. Well, the bank, what was its act? It refused further lending. But was this an act? Just to go back to the wording of the legislation, was that act a course of conduct which detrimentally affected in a material way the likelihood of accrued scheme benefits being received? Well, no, because the failure to lend the additional amounts didn't cause any detriment to the scheme. It was the borrowing of the additional amounts from the new lender and the use of those proceeds to repay the dividend, to repay the loan, so that the parent could pay the dividend in circumstances when they knew the customer was likely to walk, that did the damage. But even if that act element had been met, the regulator makes clear that it thinks the bank has got a reasonable excuse. It's a commercial lender, and it was entitled to assess its commercial interests and decide whether or not to extend its facilities. Well, what about the new lender? What did it do? It claimed the entirety of its outstanding amounts, fees and interest, and enforced its security in order to get that. Does that meet the act element? Regulator thinks yes. I think that's questionable, but okay, if that's the regulator's view. Then looks at whether the mental element of the act was met, the offence was met as well. Well, the lender would have been aware on the effect of the pension scheme as creditor. So the regulator's view is yes, that met the mental element of the offence. But this is where reasonable excuse comes in. The lender had a reasonable excuse. It acted honestly and in good faith in lending to the employer. It doesn't owe any duties to the scheme or to the employer. Now, if the lender had known that the customer was about to walk and the purpose of the extended loan was to allow the employer to repay working capital and pay a dividend, would the reasonable excuse have been met? Possibly not. So again, if you're a lender, you're obviously going to be doing due diligence. There's an element of be careful what you ask. There are some things that it is maybe better not to know. Because the lender took action to recover the amounts owed to it after triggering administration, the regulator also considered whether it could prosecute under Section 58A, a course of conduct preventing the scheme from recovering all or part of a Section 75 debt, and the regulator's code explains that it's the same thought process. The act and mental elements of the offence are met, but the lender has a reasonable excuse. And as far as the customer is concerned, what did the customer do? The customer withdrew its business. The regulator says, well, the act element is met, again, questionable, but the mental element is not, because the customer could not have known that the effect of it withdrawing its business would cause the employer to collapse, and that the pension scheme was so dependent on the employer for the Section 75 debt that it would cause the pension scheme severe detriment. In any event, even if the mental element had been met, the regulator makes clear that the customer would have a reasonable excuse. It wasn't acting to try and disadvantage the pension scheme. It was just acting as a customer buying services from a business. So I think that's all we had to say on corporate refinancings. I'm very happy to answer questions if you'd like to type them into the chat. Otherwise, thank you very much for listening and for coming to the webinar, and we look forward to seeing you in the new year.
Thank you very much.